any action instituted after the period is said to be statute bar, and any right of the plaintiff to commence the action is said to be extinguished by the said law. When an action is said to be statute bar, what it cannot is that the plaintiff may have an actionable course of action, but his recourse to judicial remedy is voided. Counsel refers to Section 2A of the Public Officers Protection Act, laws of the Federation, and which provide where an action, prosecution, or other proceeding is commenced against any person for any act done in pursuance of execution or intended execution of any act, authority, or in respect of any alleged neglect, default in the action of any such law or duty or authority, the action prosecution shall not be instituted unless it is commenced within 3 months. Counsel submitted that the claimant's course of action, if any, accrued on 14 September, which was the effective date of dismissal from service, i.e. first dependent applicant, while the instant suit challenging the said dismissal was filed on the 2nd day of February 2022, well over a period of 4 months. Counsel contended that in the circumstances, the claimant action is started by having been commenced more than 3 months. In support of this submission, counsel relied on the case of Basi versus Minister of Defense. He also relied on NNPC versus Abdurrahman. It is the submission of counsel that the effect of Section 2A of the Public Officers Protection Act is that an action against a public officer in respect of any act done in pursuance of execution of any act or law or public duty or default, same can only be commenced within 3 months next after the neglect or default. Counsel provided the yardstick for applicability of Section 2A. Counsel also argued that, taking into consideration the said yardstick, this case is statute bar. He also relied on Idigbe versus Ade Parasin. In opposition to the preliminary objection, the claimant filed a reply to the objection in oral adumberation before the court. Innocent C. Obert, Esquire, counsel for the claimant, leading David Echo and S.E. Lesato, Esquire, adopted the reply to the objection as his argument in opposition. In the reply, a sole issue was formulated for determination. I'm going to skip reading the submission to save time because there is no light, and counsel can remove anyone that want to remove his wig and gown can do so. We have problem with our generator, and I think there is general light problem in Calabar. Since yesterday, there was no light. So on the second preliminary objection filed by the third defendant, the third defendant is asking the court to strike out the name of the third defendant as being not a necessary party, and also that there is no reasonable course of action disclosed against the third defendant. I have captured the argument. Counsel submitted twin issues. I have captured the argument of counsel. So I'm also going to skip reading the submissions of counsel. I will go straight to the decision of the court to save time. I have carefully considered the processes so far filed, and in particular, the 2 notices of preliminary objection filed by the defendants. I have equally considered the written and oral submissions of counsel for both sides. In obedience to the tried position of the law, I shall first consider the objection on the limitation law, which borders on jurisdiction to entertain the claim. The first and second defendant are of the view that the claimant's action as it is presently constituted is statute bar for having been filed beyond the 3-month period allowed by Section 2A of the Public Officers Protection Act for any suit or action to be instituted against a public officer, while the claimant insists that the first and second dependent objection is baseless as it was based on misconception of law and the facts constituting the cause of action giving the claimant right of action. When a party is in a suit, alleges that an action is started by, it is in effect saying that the legislature prescribes certain period of limitation for institution of the action. The statute that prescribes such period and regulate the subsistence of the cause of action is known as statute of limitation. Where a statute of limitation prescribes the period within which an action must be commenced, legal proceeding cannot be properly or validly instituted after the expiration of the period. When an action is started by, a claimant who might otherwise have had a cause of action loses the right to enforce it by judicial process because the period of time laid down by the limitation law for instituting such an action has elapsed. See the case of Idigbe versus NNPC. See also Odubepo versus Fowler. See also Sanda versus Kukawa local government. See also Ekiabu and Aliri. Generally, to determine if an action is started by, it is the originating process that the court should look at to find out the date when the wrong was said to have occurred and the date the suit was filed before the court. But where the objection that a suit is started by is considered and determined after the conclusion of evidence by both sides, all the processes and evidence before the court must be considered, especially where the objection is determined as part of or along with the final judgment on the merit of the dispute in the case. This approach the substantial justice of the matter who knowing very well that their claim is already started by, praises their case in such a manner as to hide or misrepresent the facts, to exploit the principle that only an originating process should be considered in determining issue when a cause of action accrued, and abuse of process by sending it on a futile trial of a stale course of action that it lacks jurisdiction to try. In this case, the preliminary objection was brought before the evidence is taken. Therefore, the court is only obliged to look at the originating process and the pleadings of the claimant in determining when the course of action accrued and whether the suit is started by or not. See the case of APC versus Lere. See also Nwekore versus Adewumi. See also Egbe versus Alhaji. It is therefore right that where the law prescribes a period of instituting an action, proceeding cannot be instituted after the prescribed period. See INEC versus Obadibo local government area. The court over the years have stated the rationale or justification for supporting existence of statute of limitation to include gingering the person that has a cause of action to pursue with reasonable diligence his case, as long as dormant claims are more or cruel than justice in them. Also, evidence may have been lost, thereby posing problem of providing a stale claim. A period proving a stale claim. A period of limitation begin to run from the date on which the cause of action accrued. Therefore, in order to determine whether an action is started by, all that is required is for one to examine the writ of summons or the statement of facts in the case at hand, and the statement of the complaint and statement of facts in this case, alleging when the wrong was committed, which gave rise to the cause of action. If time on the writ is beyond the prescribed period allowed by statute, then the action is started by. The Supreme Court in Egbe versus Adeparasi laid down this formula for determining cause of action. Similarly, in Wohoren versus Emeryua, the Supreme Court said, for the purpose of determining whether or not an action is started by, the period of limitation is determined by looking at the writ of summons and the statement of claim only. I will, however, add where one has been filed, So if there is none that is filed, that cannot be done. It is from either or both the process of both of the processes that one can ascertain the alleged date when the wrong was in question is said to have occurred or been committed, thereby giving rise to the claimant the cause of action he is claiming. When that is ascertained, the date compared with the date of filing of the complaint can be determined from the process file, and that will be determining factor. See the case of Savannah Bank of Nigeria versus Span at length. See also the recent decision of the Supreme Court in Idachaba versus Federal University of Agriculture, Makodi. Where the Supreme Court has this to say, it is the law that the process filed by the plaintiff should be the mirror to look into in determining whether an action is caught by the statute of limitation or not. All that is required is for one to examine the writ of summons and the statement of claim alleging when the wrong was committed, which gives the plaintiff a course of action, and comparing it with the date when the writ of summons was filed before the court. If the time on the writ of summons is beyond the period allowed by limitation law, then the action is started by. See also Aremo versus Ade Kanyip. Applying the principles or the guidelines as stated in the above cases to the case at hand, the claimant commenced this action on the 2nd day of February 2022 by a general form of complaint. It was averred in paragraph 26 of the statement of facts, which is the pleading of the claimant, that on 4th day of November 2021, the claimant was served with a letter dated 7th of October 2021, dismissing her from service of the first defendant with effect from 14th day of September 2021. From the written and oral submissions of counsel, the bone of contention is on the date when time begin to run for the purposes of limitation of period of 3 months as provided in Section 2A of the Public Officers Protection Act. The defendant are of the view that the period started running from the date of the effective dismissal of the claimant, that is 14th day of September 2021, or from the date of the letter of dismissal, that is 7th day of October 2021, while the claimant insisted that the date when time begin to run for the purpose of limitation law is the time when the claimant becomes aware of the action of the defendant in dismissing the claimant from the service of the defendant. In view of this, counts the claimant insisted that the action is not started back. In this case, by the facts pleaded by the parties, it is deducible that the claimant and the defendants are public officers of the Federal Republic of Nigeria. The former in contract of employment is in contract of employment or contract of service under the latter. It is without argument that they were both regulated by the Public Officers Protection Act. Section 2A of the Public Officers Protection Act states as follows. I have quoted, I will jump reading it. Whatsoever might have been the position taken by the parties, the law regarding the accrual of cause of action and when time begins to run for the purposes of limitation is well settled, that the time begins to run or counted when the claimant fully becomes aware of her dismissal from service, as that is the date the course of action accrued, and time begin to be counted for the limitation law of three months period from that date when the claimant becomes aware of the dismissal from service. After a careful review of the authority cited by the parties and the position taken by counsel for the parties on when time begin to run, I agree with the learned counsel for the claimant that the claimant's action accrued on the 4th of November 2021 when she became aware of the dismissal of her dismissal by the first defendant as per the letter of dismissal dated 7th day of October 2021. The claimant, by the general form of complaint, filed this suit on the 2nd day of February 2022, challenging her dismissal from service. As stated earlier on, the law is well settled that the right of action accrues when person that sue becomes aware of the wrong. See the case of UBA versus BTL Industries. See also the case of Owonibore Technical Services Limited. See also Mulima versus Usman. See also UBN versus Umediago. It is clear to me from the decisions of the apex court of the land, the reasonable and just conclusion to reach on issue of course of action and when time begin to run is when the claimant becomes aware of the dismissal from service of the first defendant, which is 4th of November 2021, as per the amendment in paragraph 26 of the statement of facts, which has not been disputed by the defendant. Since the claimant becomes aware of her dismissal on the 4th of November 2021, that was the day the course of action accrued, as well as the day to be reckoned with when determining the 3 months period within which an action against a public officer shall be instituted before a court of law. If the date of accrual of the course of action in this case, that is 1st of November 2022, and the date when this action was filed, that is 2nd day of February 2022, are compared, it will be without any doubt that the claimant instituted this action within the 3 months period allowed by the statute of limitation. Therefore, the claimant action is not in violation of any limitation law. This suit is competently before the court. It is not started by I so find and hold. Indeed, Section 2A of the Public Officers Protection Act or Section 6, subsection 1 and 2 of the Nigerian Customs Service Board, which is immaterial with the provisions of Section 2A of the Public Officers Protection Act, are inapplicable to the case at hand for the simple reasons that Public Officers Protection Act does not apply to contract of service or work and labor done, which is an exception to the applicability of the provisions of Public Officers Protection Act. See the case of Attorney General of Rivers State versus Attorney General of Bayelsa State. See also Nigerian Port Authority versus Controziani Parusa. See also National Revenue Mobilization, Allocation and Fiscal Commission and others versus Ajibola Johnson and others. See where the Supreme Court per Adiola JSC as season was stated that there is no doubt a careful reading of the respondent claim will show clearly that it is a contract of service. It is now settled law that Section 2A of the Public Officers Protection Act does not apply to cases of contract. See Nigerian Port Authority versus Constriziani. See also Osun State Government versus Delami Nigeria Limited. Delami Nigeria Limited. In dealing with this issue, the court below had found that the parties' right to action and access to relief cannot be extinguished on the basis of Public Officers Protection Act, as it does not apply to cases of contract. The court below went further as follows: assuming the appellant had that statutory cover of the Public Officers Protection Act, it has to be restated at the risk of overflowing a legal principle that certain factors would debar that operation of the Act. Abuse of office will deprive a party who would otherwise have entitled to the protection of Section 2A. Or for abuse of power, or for personal gain, or to show undue favor for another, or to wreak vengeance on an opponent. The court below finally concluded that the appellants are not covered by the provisions of the Act to render the action statute valid. I have no slightest difficulty in holding that the appellants are not covered by the provision of Public Officers Protection Act to render the respondent action statute bar. End of quote. It is clear from the above decision of the Supreme Court that the claimant action as it is presently constituted is competently before the court. It has not been affected, or it has not been barred by Section 2A of the Public Officers Protection Act, I so hold. Having dealt with the objection of the first and second defendants, I shall now deal with the objection of the third defendant, which borders on misjoinder and course of action, lack of course of action or reasonable course of action. It is the submission of counsel for the third defendant that it is not necessary party to be made dependent in this suit, as the suit of the claimant, especially the relief being sought by the claimant, do not disclose any injury meted by the third defendant on the claimant. It is the submission of counsel that at best the third defendant may have been joined in this suit because of supervisory role placed over the first and second defendant. It is submitted that the first and second defendant are autonomous bodies that who can be bound by order or decision requiring no further obligation on part of the third defendant to ensure that the first and second defendant comply with the order or decision of the court. Counsel concluded on this issue that looking at the reliefs, presence of third defendant is not necessary or required to effectively and effectually or completely adjudicate upon the issues submitted before the court for adjudication. On the second leg of the objection, counsel submitted that no reasonable course of action has been disclosed against the third defendant, as the only relief against the third defendant is vague. In response to the claimant's argument, the claimants argued that having regard to the peculiar facts of this case, the relevant provisions of the law establishing the first defendant, the submission of the third defendant on necessary party and reasonable course of action are misguided and misconceived. It is settled principle of law that non-joinder or misjoinder of parties may not ipso facto be fatal to a proceeding, as it cannot defeat a course of action. See Ekpere versus Aporije. See also Anya Duha versus NRTC Limited. The absurdity of misjoinder is that it creates a situation where the claimant would be unable to pursue the case against the misjoined party decently and properly in all probability. However, in civil cases, a claimant has a choice as to who to join or whether or not to continue his suit against a person whom he had joined in the suit at its commencement. Accordingly, a court will not compel a claimant to join a party against whom he has not made a claim. However, when a suit has been filed, the court becomes dominus litis and thus assumes a duty or responsibility to ensure that the proceeding agree with the justice of the case by joining either as claimant or dependent all persons who may be entitled or claim some share or interest in the subject matter of the suit, or who may likely be affected by the result if they had not been already been made parties, or and that the court also has the power to strike out any party who does not who seems not supposed to have been joined as a party in the matter. In the case at hand, the party praying for striking out is already a party before the court. It is the law that a claimant has a choice to pursue any party against whom there is a claim or relief being sought. The claimant in this case, in this suit, is free to join or pursue any party against whom she has a claim against. In law, parties are categorized depending on their distinctive role and interest in a given matter. That's why we have proper parties, desirable parties, and necessary parties. Proper parties are those who, though not actually interested in the claim, are joined as parties for some good reason. Desirable parties are those who have an interest in the suit or may be affected by the result thereof. Necessary parties are those who not only have interest in the matter, but also who in their absence the proceeding could not be fairly dealt with. That is the issue or question to be determined in the matter between the existing parties should be one which cannot be properly settled unless they are parties to the action. See the case of Green versus Green. See also Padua versus Jatau. See also Buhari versus Yusuf. See also Yusuf Ade versus Ademi. See also Gani Tazan Maritime Enterprises Limited versus Kabile Resources Investment Limited. It is always the facts in a given case that determines the nature or category to which parties to the action belong. The side dependent in this case was assigned responsibility by the Nigerian Customs Service Board Act as the chairman of the board. See Section 2, subsection 1A, 3, 4, subsection 1 and 2 of the Nigerian Customs Board Act. One of the responsibility and function of the board is discipline of members of staff of the service, i.e. Nigerian Customs Service. The claimant in this suit was employed by the Nigerian Customs Service, and in the exercise of disciplinary powers conferred on the board, which was chaired by the third dependent, the claimant was dismissed from service. This suit was instituted by the claimant to contest the validity of her dismissal from the service. Therefore, it cannot, in all sense of responsibility, be said that the claimant does not have a course of action or a reasonable course of action to pursue. Having regard to the above stated facts, which are evident in the Nigerian Customs Board Act and the pleadings of the claimant before the court, I have no slightest hesitation in coming to the conclusion that the third dependent in this case is proper and desirable party to be made dependent in this suit, and there is disclosed a reasonable course of action against the dependent. The mere fact that the third dependent is not a necessary party does not mean that it cannot be joined as a party. Having found that the third dependent is a proper and desirable party, it is properly before the court. See the case of Gani Tazan Maritime Enterprises versus Kabile Resources Sufra. See also Thomas versus Olu Posoi. On the whole, the two preliminary objections failed and woefully failed, and same I hereby dismiss for lacking in merit. I make no order as to cause. Give me this for hearing. 24. This case is hereby adjourned to 24th of October 2023 for hearing.